On this episode of Law Weekly, we look at some of the updates in the alleged defamation case of Lagos-based lawyer Dele Farotimi against very senior legal practitioner Areafe Babalola, senior advocate of Nigeria. We'll also bring you the reactions of the Attorney General and Commissioner for Justice, senior advocate of Nigeria Lawal Pedro, who was also mentioned in the book Nigeria and its Criminal Justice System. Also showing on the program, the Human and Environmental Development Agenda Header Resource Center hosts events to commemorate the International Anti-Corruption Day, makes case for combated efforts to tackle corruption. Plus our recap of the top trending stories in the news. Hello and welcome to the program. I am Shola Shuyeli. After the remand of Dele Farotimi at the Correctional Center in Ekiti on the orders of the Magistrate Court, the police in the state filed a fresh charge at the Federal High Court, also in Ado-Ekiti. The fresh 12-count charge focused on Farotimi's online interviews where he reiterated allegations made in his book. On Monday, December 9th, Farotimi was taken before the Federal High Court at Ado-Ekiti where he was arraigned on the fresh charge and granted bail in the sum of 50 million naira with one surety in like sum. The case was then adjourned to January 29, 2025. On Tuesday, December 10, Farotimi was back at the Magistrate Court where his bail application was taken on the 16-count charge pending against him before that court. The charge at the Magistrate Court borders on the allegations made in his book. The first hurdle the defense team had to cross was the objection to the appearance of a senior advocate of Nigeria, Yinka Olumide Fusika, on the ground that a senior advocate could not appear before an inferior court. Magistrate Abayomi Adeosun reserved his decision on that objection till a later date. The magistrate also adjourned till Friday, December 20th, his ruling on the bail application. Outside the court, supporters of the parties engaged in a war of words. Now, there has since been a series of lawsuits on the matter. The managing partner at Afe Babalola's law firm, senior advocate of Nigeria, Kehinde Ogunmiju, filed a civil suit on behalf of the firm against Farotimi for the alleged defamatory statements in his book. Similar suits were also filed by other partners of the firm, senior advocate of Nigeria Adebayo Adenipekun in Oyo State, senior advocate of Nigeria Oludaramola in Ogun State, and Ola Faru in Rivers State. On Wednesday, December 11th, Justice Peter Kekemeke in the suit filed at the High Court of the FCT granted an order of interim injunction restraining Farotimi from further publishing, selling, or circulating his book. The judge also temporarily restrained agents, publishers, and distributors from further publishing or selling the physical, hard, digital, or soft copies of the book by any means, including on social media. The court also ordered law enforcement agencies to seize copies of the book wherever it may be found. A somewhat similar order was also made in the High Court of Oyo State. Law Weekly learned that similar suits will also be filed in Lagos and Osun states. The law firm of Afe Babalola has also written a 90-page petition to the Legal Practitioners Disciplinary Committee, LPDC, asking it to strike out the name of Dele Farotimi from the roll of legal practitioners in Nigeria for violating certain provisions of the rules of professional conduct for lawyers. According to the petitioners, Farotimi engaged in conduct which is unbecoming of a legal practitioner by making false accusations against the Supreme Court and the legal profession. The petitioners also stated that the contravention of these rules by Farotimi prompted the petition to protect the dignity of the legal profession, the dignity of the court as the temple of justice, and to uphold the standards of the legal profession. The Legal Practitioners Disciplinary Committee, LPDC, is the regulatory body that investigates and addresses misconduct among Nigerian lawyers. The body can order that the name of a legal practitioner be struck off the roll of lawyers kept at the Supreme Court, and such decision is subject to appeal at the Supreme Court. In Lagos, the Attorney General Lawal Pedro held a press conference to speak about some new legislations in the state. I used the opportunity of the press conference to ask him to explain his role in the case of Dele Farotimi and Areafe Babalola. Farotimi, in his book, had dedicated a whole chapter to talk about the role of Lawal Pedro. He alleged in the book that Pedro, at the material time, was the Solicitor General of Lagos and had allegedly corrupted himself, abandoned the interests of the state, and became the undisclosed counsel to the Eletu family, thus betraying the public interest. Here's what Pedro had to say about the issue and his role in the whole saga.
I think the man got it totally wrong. Totally wrong. And what I did, and I've not stopped saying it, if it happens again, I will do the same thing. It was a total misconception of the old scenario. And if you know, this is a case between two families, Ojomu and Eletu. And Lagos State government was never a party to the suit. So they did their cases, I don't know, maybe Dele, Farotimi, whether it was a counsel to one of the parties or an assignee or a company that bought from one of the parties. I wouldn't know. What would have angered him most, I don't understand why he went well out. Well, he may have misread it, but I'll put the facts straight. After the judgment, the whole of Nikon Estates, UAC, French colony, let's just take the entire Osaka London, were to be bulldozed. We were all here. I was also general, and there was already bulldozer to begin to escalate. Whoever owns the land, owns whatever is on it. And then Mr. Governor drew my attention to it. There's going to be a problem. So what I did was to say, hey, wait a minute, this is Lagos. You can't be destructive, Eletu. Can you come to a round conference table? What is happening? Hey, we got judgment, Supreme Court. After Supreme Court has delivered a judgment, what else? Unless you go to your appeal to God. So I said, well, and I told the family that what you had is judgment on land, not on the structures that you want to begin to demolish. I'm also aware of the law that whoever owns the land owns once on it. And because the case was in court for how many years? More than that, from High Court to Court of Appeal to Supreme Court. And while the case was ongoing, there were lots of transactions going on the land. Lagos State government issued C of O's on part of the land. Lagos State government granted consent to people, granted building approval to people on the land. And this is the same property to be demolished, just because courtesy of a Supreme Court judgment. And I said, no. And with the support of Mr. Governor then, Mr. Babatunde Fashola, Senior Advocate of Nigeria, I said what we can do is to compromise this judgment by giving Eletu another parcel of land, like Banana Island. They can sandfield, and they can use that as replacement. And that is what they are enjoying today. That's exactly what really happened that I did then. But of course, while the family agreed, what they did not do is to disclose to their counsel, Chief Afe Babalola, that they've reached an agreement with Lagos State government. And I think Chief Afe Babalola felt really, really offended. How can they settle? What has happened? And there's nothing to hide. It's all in the media then that maybe I took over Chief Afe Babalola's client. I collected the $10 million that was supposed to be this thing. And so when that one went out, I went to Ado-Ekiti. I saw Chief Afe, what's all this one? He said, I know, this and this are what we are doing. Chief Afe never believed that the governors have approved that another land be given to Eletu people. So when people now begin to talk, say, maybe he used lawyers, because different lawyers came into the transaction with the Eletu people. And there's none of these lawyers that I do not know. So they now thought maybe I'm the one that called this lawyer in to change my father, Chief Afe Babalola, which was not the thing. So that's why I said, and I said, if the same thing repeats itself today, I will do the same thing, because we can't be destructive. If what you have won in the Supreme Court is parcel of land, is about maybe 280 or something acres, and truly, the first judgment came, he referred to 10 hectares or 10 acres. And they went back to the Supreme Court. Supreme Court saw the omission and corrected the step. It's accidental slip, which we know of, and that was corrected. So that's why I was wondering, mine is a minor out of it. So I just look at my colleague. For him, the way he went, maybe he was totally annoyed. And to me, with due respect to him, he went overboard. Unless he has that evidence to show that all the names he put there were actually compromised. Even when they got to Lagos High Court here, they were trying to do enforcement. A judge signed writ of possession, enforcement for 10 hectares. And that was when I came in to say you can't demolish. So I think they petitioned Justice Phillips, petitioned Justice Atilade over this same judgment. But what we have done in Lagos is to save the whole of Upper London. And that's why it's standing today. If the government of Lagos State, who was never a party to the suit, had not come to rescue, if anybody decides to demolish all those properties there, they will be gone. Nobody will say anything. It's enforcement of judgment of the courts. So that is it. So to me, I look at him, I keep my cool for now. For now.
The AG also spoke about the new laws recently signed into effect by the governor of Lagos State, Mr. Babajide Sanwo-Olu.
Lagos Consumer Protection Agency law. This law signifies a leap forward in enhancing consumer rights in our state. As Lagos continues to be a hub of commerce, business, and trade, it is imperative that the interests of our residents are safeguarded. The law establishes the Lagos State Consumer Protection Agency. It is an autonomous body charged with investigating unfair trade practices, consumer fraud, substandard products, and deceptive practices. The law in Section 41 empowers the agency to enter, search, seal, and seize. Section 60 or 7 of the law, a person or enterprise that contravenes the provisions relating to a prohibited agreement, trade agreement, prohibited trade practices, prohibition of unfair trading, all may be convicted on a fine no less than 5 million naira. The next law that was assented to by Mr. Governor is the Human Organ Harvesting and Tissue Transplantation Law. Practitioner or any person shall not conduct or cause to be conducted any activity relating to any human organ transplant without being registered under this law. Section 45 provides for restriction on removal of organs from minor or mentally challenged person. There are provisions therein. Section 50 provides for prohibition of advertisement relating to buying or selling of any organs, tissue or blood from the body of a person. The section provides that it is an offense and carries penalty. The penalty therein include penalty of almost 5 million naira or a term of not exceeding 10 years custodial sentence or both. The third law is the Lagos State Enforcement Training Institute law. This law established the Lagos State Enforcement Training Institute and provide a comprehensive curriculum for law enforcement officers across the state. It also aimed to equip them with knowledge, tools, and ethical standards required to carry out their duties effectively and fairly, promoting a more transparent and accountable law enforcement system. This, I must add, is our silent journey to state policing. Anytime Nigeria as a nation is ready, Lagos is ready for state policing. The next law is the Victim Assistance and Witness Protection Law. This law is a crucial safeguard for victims and witnesses, providing them with the essential protection and support during and after criminal proceedings. Section 50 in particular of that law makes provision that it is the duty of hospitals and medical facilities to give immediate medical attention to certain victims in cases of emergency and get reimbursed for the cost of the treatment in situations where the victim is indigent or the family members cannot be reached. The agency is empowered to take appropriate and effective measures to assist and protect victims and witnesses from potential or existing threats, harm, reprisal, retaliations, or intimidation. The last of the laws recently assented to by Mr. Governor is Lagos State Fire and Rescue Service Law. The law recognizes and strengthening the state fire service and rescue services, making them more responsive and effective in protecting lives and properties. Section 33 mandates a developer employed for building construction site to ensure that the building is designed, constructed with standard fire prevention, detection, alarm devices acceptable to the service. Section 56 to 62 mandate every firefighting equipment dealer, consultant, private organization or company in the state to apply for registration with the service and be issued a certificate of which shall be renewed every 5 years upon payment of prescribed fees. In conclusion, these laws reflect our commitment to progress, security, and justice in Lagos State.
Welcome back. On Monday, December 9, the Human and Environmental Development Agenda HEDA Resource Center marked the International Anti-Corruption Day with a series of impactful events dedicated to raising awareness and driving action against corruption in Nigeria. The day kicked off with an anti-corruption walk, which was followed by a conference with the theme engaging young stakeholders in attaining global cooperation in the fight against corruption and repatriation of illicit assets. The event focused on the urgent need for the establishment of the International Anti-Corruption Court, with key stakeholders passionately championing this court.
Members of the legal profession, representatives of law enforcement agencies locally and internationally, members of civil society, the media, youth, and other critical stakeholders are gathered here and online at the instance of the Human and Environmental Development Agenda HEDA Resource Center, in collaboration with the Integrity Initiatives International and the MacArthur Foundation, for this conference on international anti-corruption courts and public presentation of the compendium on 100 high-profile corruption cases in Nigeria. The chairman of HEDA, Olanrewaju Suraj, says this event to commemorate the International Anti-Corruption Day is geared at improving transparency and accountability in the country, and this requires the involvement of everyone, especially the youth.
It is very important that we don't leave, the fight against corruption to law enforcement agencies alone. It is the duty of every one of us, and it is in the interest of every one of us that we make sure that we don't allow our engagement of the law enforcement agency to actually also either wane or also reduce the engagement of the agencies to just politicians and also their appointers. I mean, the politicians usually don't fight corruption easily, except the citizens, which are we, the civil society, and also the media, are able to set the pace for them and continue to also remind them and challenge them on the need to fulfill the mandate for which they are all established. So it is on this note that HEDA is also bringing us together to mark today and also see how we want to move beyond just talking within us as the elderly and see how we can get our young people to also take interest, in the discussion and the issues of corruption.
The chairperson of the event, Senior Advocate of Nigeria, Mrs. Fumi Falana, reminded participants that corruption is a violation of the fundamental rights of the people.
Prosecuting highly profiled corruption cases is very, very necessary, and we will need an international anti-corruption court. Finally, to the youth, I leave this charge. Be relentless in your pursuit of integrity, which is very important as you look up to the other societies, pick up what is good in them and discard what should not be emulated. Whether through activism or innovation of civic engagement, note that integrity is essential.
The keynote address on international legal mechanisms towards global cooperation in the fight against corruption and repatriation of illicit assets was delivered by Professor Chidi Odikalu, who provided profound insight into international legal strategies to combat corruption.
Anybody who can steal your elections can steal anything. That, I think, is one place where we can begin. And here, I also, we also need to begin to address people like me, professors. It is professors who will come and announce fake results and declare as winners people who actually lost elections. The second category I also fit into, lawyers. Lawyers and judges will announce as winners people who were declared losers and who know that they lost because of corruption. So let us all begin with one place. Today, in Nigeria, it's even difficult to have consensus on this very basic thing that elections should matter, the votes should matter, and the winners should be declared based on counted votes. If you put people to a poll in this room on this particular issue, we will not be able to agree on it. And if we cannot agree that votes do matter, and judges should not be the people calling the results of elections, then we should have no business talking about repatriation of assets.
Other speakers also share their perspectives on the theme.
I think the challenges we face today is the next step in this journey. And I think, as many of the speakers have spoken to, that next step is made even more challenging by the increasingly complex, financialized, and globalized nature of corruption and illicit financial flows. And I think targeting that range of activity requires, I think, two things. One, global cooperation on a scale much greater than we're currently doing, much greater cooperation to share information between law enforcement agencies, to work on enforcement mechanisms such as this anti-corruption court, and to learn lessons and sort of share information between each other, both at the level of governments and at the level of citizens, learning from what works in one country and taking it to another.
We must invest in youth leadership through training, mentorship, and capacity building programs. Government must enact and enforce policies that protect young whistleblowers and create opportunities for youth to participate in decision-making at all levels.
At the end of the speeches, the compendium on 100 high-profile corruption cases in Nigeria was also launched to serve not only as a tool for accountability, but encourage Nigerians to take ownership of the process and play their part in combating corruption.
And just before we go, a quick look at some of the major court stories we tracked this week.
We begin with the report that the Court of Appeal sitting in Abuja has set aside all orders restraining the Central Bank of Nigeria and the Accountant General of the Federation from releasing funds to the Rivers State government. The three-member panel, presided by Justice Haman Barka, held that the subject matter was not within the jurisdiction of the court relating to the revenue of the state. While allowing the appeal of the Rivers State government, the appellate court also set aside all the orders made by the trial judge, Justice Joyce Abdul Malik, stating that it was unconstitutional for her to make orders restricting the Rivers State government to receive funds due to the state from its consolidated revenue fund. The appellate court held that the lower court overreached itself and did not have the jurisdiction to entertain the matter. Staying in Abuja, Justice Emeka Nwete of the Federal High Court has granted the immediate past governor of Kogi State, Yaya Bello, bail in the sum of 500 million naira with two sureties in like sum. The court granted bail after the former governor pleaded not guilty to the 19 counts charge brought against him by the Economic and Financial Crimes Commission, EFCC. He is facing trial for allegedly laundering funds to the tune of 80 billion naira. According to the court, the two sureties must have landed property within the jurisdiction of this court. They must also swear to an affidavit of means, while the title deeds of the property must be verified by the court registrar. The defendant was also asked to submit his international passport. He would remain at the Kuje Correctional Center pending the perfection of the bail conditions. The case has been adjourned to February 24, 2025 for continuation of trial. And we round off with the report that the Economic and Financial Crimes Commission EFCC has asked Justice Rahman Oshodi of the Lagos State Special Offences Court sitting in Ikeja to strike out an application filed by a former governor of the Central Bank of Nigeria, Godwin Emefiele, challenging the jurisdiction of the court. Through its counsel, Senior Advocate of Nigeria, Farotimi Oyedepo, the Commission described the application as a ploy to frustrate the prosecution from conducting its constitutional mandate, which includes diligent prosecution of economic and financial crimes. In his application challenging the powers of the court, Mr. Emefiele, through his counsel, Senior Advocate of Nigeria, Olalekan Ojo, had argued that Emefiele could not be tried in any state high court in Nigeria for alleged abuse of office, as this raises significant constitutional and legal issues. The senior lawyer also argues that counts 1 to 4 of the 26 count charges filed against him by the EFCC are unconstitutional, as they are not based on any existing laws in Nigeria. After listening to all the arguments, Justice Rahman Oshodi fixed January 7 for his ruling.
And that's the program for today. Do remember to check out the Channels TV website for a replay of this episode of the program as well as past episodes. Please also send in any feedback via our social media handles. I'm Shola Shoyeli. Thank you for watching and see you next week.